Okay, well, I'd like to welcome everybody to the inaugural masterclass for Connectpreneur. This is a service that we're providing to our presenter alumni, and I believe almost all of you are presenter alumni, with the exception of a couple of VIPs. I want to introduce our co-hosts. We have Skylar Rollison and Laura Hill. So if you guys have any questions, comments, having any technical difficulties, please private message them on the chat. We have set up a Slack channel rather, for everybody in this particular group, in this masterclass, so that Anthony and his colleague Lisa, who can't be with us today due to a personal matter, but Anthony and Lisa can participate with you, not just today, but also going forward if you have lingering questions. So very briefly, today we're going to have about a 40-minute lecture from Anthony, and I'll introduce Anthony momentarily. After which we'll run into a Q&A session. The Q&A session will be moderated by Skylar, who's our community manager for Connectpreneur. And if you have any questions, you can just feel free to put them right into the public chat box, or if you want a private chat with Skylar or myself, we'll make sure that we address your questions. So again, we do have the Slack channel, so please do join the Slack channel. And before we start, we have a couple of polls for you. So we'll put up the first poll, which is, I want to know, what's your status on fundraising right now, right? Are you currently raising? Are you imminently raising? Or are you not raising? And if you could just indicate that, that would be helpful. Okay, so we have 10 of you are currently raising, or 11 of you, and 6 of you, 12 of you are currently raising, and 6 of you are imminently raising. So that's good. And then for those of you who are raising, we have another question in terms of amounts. So are you raising 0 to 1, or 2 to 3, 4 to 10, or over 11? Just to give us an idea, or give Anthony an idea of, what types of investment you're looking at. We have 12 of you are raising under $1 million. We have 6 of you raising between 4 and 10 million. 1 is raising 2 to 3 million, and 1 is raising over 11 million. So we have a variety of different investor types here at play. So thank you guys for participating in the poll. So now it gives me great pleasure to introduce our instructor for the day. Anthony Millin is a good friend. He's also a great friend of Connectpreneur. Many of you know Anthony already because he's probably introduced you in the past. And if you haven't met Anthony, he's someone that you would benefit from knowing. He is, first and foremost, he is an entrepreneur. He's a multiple-time entrepreneur. He has built and sold and invested in many successful companies. He's also a venture capitalist. He's a general partner at Urban Us, which is a venture capital firm with offices in California and New York. And Anthony's one of the 4 partners there. He's also got a ton of international experience, having worked and invested in China and Europe and South Africa and other places. So we're really thrilled to have Anthony. So he's much more than just a lawyer, although I would say he's probably the best in town in terms of working with companies at all stages in raising all types of capital. So again, we will have Anthony, we'll speak for about 40 minutes or so, and then we'll roll into a Q&A, and we can either do it live or you can put questions into the chat box. And again, please join the Slack channel. And with that, I will turn it over to Anthony. Anthony, thank you so much for doing this.
My pleasure, Tien. It's very exciting to be part of the masterclass series that you're launching. And as you mentioned, we're huge fans of Connectpreneur and everything that you and the Connectpreneur team do for our ecosystem. So thank you to you guys. I'm going to share my screen. Okay. So today's focus is going to be on legal aspects of raising financing. As Tien mentioned, I've been a serial entrepreneur. I've been involved in the startup ecosystem for over 20 years now, co-founding companies, a venture capital partner, and a startup attorney. And currently, I'm the founder and chair of Next, powered by Shulman Rogers, and which is a innovative new model for delivering legal services for the full life cycle of startup and emerging growth companies. We offer predictable legal fees through more than 75 fixed price packages and service bundles designed for startups. Our clients receive direct guidance from our senior attorneys through a high-touch, hands-on legal services model, and we integrate technology platforms from leading providers like NASDAQ and Carta and UShare and other best-of-breed tools to create a responsive, collaborative, transparent, and efficient client-centric experience. For information at our new website, www.next.law, you can learn a lot more about what we're doing. So please visit us there. So at the beginning of raising capital, the first step usually involves a term sheet, and this will either be something, depending on the stage of the investment, that the investors will provide to you as the entrepreneurs, or in some instances as well, this may be something that you create with your attorney and you put out to investors who are asking you for a term sheet. So it can go in either of those directions. Sometimes with the earlier stage seed financings, you're putting a term sheet together and giving it out to friends and family and angel investors. And when you start getting into later stage rounds with institutional investors, they'll often generate a term sheet and present you with the term sheet. So why is a term sheet important? It's the first document that's prepared and negotiated, and it highlights the key terms of the transaction. And the benefits of using a term sheet rather than going straight into doing the definitive documents is, number one, it flushes out the key deal terms at the very beginning or early parts of the negotiation. This enables earlier discovery of deal breakers. So you don't want to get 6 weeks down into a negotiation with investors only to discover there were some deal breakers that at the very beginning could have been flushed out and saved you a lot of time that you were investing with that particular investor. Also, once you have a term sheet, it makes it a lot easier to do the drafting and negotiating of the definitive documents later. So although it maybe adds a little bit more time up front to get that done, over the long term of the deal, having a very clear term sheet is very helpful. It also makes it harder for parties to change their positions later on. So if you've negotiated a term sheet and signed it, and both of you have signed the term sheet, and the investor later on, for instance, comes back to renegotiate, or somebody who's part of that deal looks to renegotiate, you can always pull out the term sheet and say, look, we've already been through this. It's been negotiated. We signed off on this. Unless there's been a substantive change in the underlying business, people shouldn't be changing the terms, that the key terms that they agree to. Term sheets are generally non-binding. There are certain provisions that sometimes show up as binding. One is confidentiality sometimes shows up. Sometimes investors will ask for an exclusivity period. The governing law that governs the term sheet, those binding clauses, and sometimes the talking about who's responsible for attorney's fees, normally it's each party is responsible for their own fees, is sometimes shows up there as well. Then the next thing when that we're going to talk about are the different types of securities when you're raising capital that can show up. So first is common stock, and this could be voting or non-voting. This is what founders usually are issued when they form the company. If it's an LLC, it could be common units. And sometimes in a friends and family round or a pre-seed financing that is priced, where you are pricing the round, you'll sometimes still see somebody getting common stock as an investor. Much more common is, or frequently used, is preferred stock. And so when you're usually doing, again, a priced round, bringing in investors in a round where you're setting a valuation for the business, you're going to be doing preferred stock. And the first round of preferred is often called Series C preferred, sometimes referred to as Series AA preferred. And then you go into the commonly referenced Series A, Series B, Series C. Each of them is a different stage of capital raising and reflects the maturity of and de-risking of the company as it moves through and raises rounds that tend to be larger than the one before. And the valuations go up as the risk goes down for the investors in these different stages. Preferred stockholders receive rights and preferences that are superior to the holders of common stock or the founders and other common stockholders. They also receive protective provisions over the common stock. And investors investing in a priced equity round, as I said, are usually issued preferred stock. And again, in an LLC, this might show up as preferred units. Another type of instrument or security for raising capital is convertible notes. And we'll talk about that. One that's becoming more and more commonly used in our deals that we're seeing. Not only is it more frequently used, but it's also getting larger in the amounts that people are raising through safes. So whereas earlier on we were seeing it with smaller amounts, now we're doing multi-million-dollar seed financings through safes as well. And then we'll talk a little bit about warrants that sometimes show up in term sheets as well, or side letters tied to a term sheet. So the first thing we'll talk about is the convertible note, which is a debt instrument with interest that usually accrues, so you're not paying interest along the way. You start with convertible notes as a common instrument in a seed financing, for instance, because it bypasses the need for an upfront agreement on the current valuation. You still have a cap, which is indicative of value, but you're not pricing the company. You're not negotiating a price at that stage. And that is very helpful because it could be very challenging to price an early stage company that's maybe just putting its minimum viable product together, hasn't got any customers yet, or has some very early users testing a minimum viable product, no revenue or no sustainable revenue yet. So the entrepreneur sees all of the upside of the business and all of its potential in looking at what the valuation should be. And the investor sees the execution risk and the market risk and the product or technology risk and the capital risk. So you've got kind of people looking at the same business from these two different viewpoints, and hard to kind of meet on valuation. So the key terms that you negotiate in a convertible rate is the interest rate. And that, like I said, is usually accrued and added to the principal on conversion. The term of the note, so how long the note goes, whether it's an 18-month or a 24-month, for instance, maturity. The discount rate, which is the discount that the note holder gets when they convert into a priced round, is the next term that's negotiated. For instance, like a 20% discount is commonly a discount rate that we see a lot. And then the cap, which we'll talk about, the valuation cap, is negotiated. And the conversion terms, so how the note converts, when it converts automatically, when it converts on a voluntary basis, when you have a corporate transaction that drives the conversion, or when it either gets repaid or converts at maturity. So all those terms get around conversion need to be negotiated as well. Usually these convertible notes are unsecured, but they could be secured, and they have priority over common and over the common holders and the preferred holders, so over the equity of the company. So let's just talk, because this is a very important concept that shows up in most convertible notes and safes, which is a cap. So the way a cap works is it's the maximum value the investor will pay when they convert into the next round. And it's there to give the investor some protection around and putting in early capital. The investor takes that capital and executes at a really high level. By the time you price the round for that company, their priced financing round, the value's gone up to 20 million or 15 million or 10 million. And the early stage investor feels like a lot of that was built on their capital, that de-risking that led to that valuation. And so even with a 20% discount, which is market rate for a discount, they may feel that doesn't give them enough protection if there's a really high next valuation, so they negotiate this cap. So if you have a company with 1 million shares of common stock outstanding, they issued a $500,000 convertible note with a conversion discount of 20% and a valuation cap of $5 million. The company executes well, and in its priced round, its first preferred stock financing, it's valued at $10 million. So for investors who came in, or if you had no cap and no discount, the valuation of $10 million, 1 million shares outstanding, so you divide by 1 million, you get $10 a share. The $500,000, we're going to ignore the interest part of that for now. The $500,000 converts at a $10 per share price or 10 million valuation. So they get 50,000 shares upon conversion. If they use the discount, they would get a 20% discount on their 10 million valuation, $8 a share, 62,500 shares. But look what happens with the cap. If it's a $5 million cap that's in there, it's $5 a share and 100,000 shares upon conversion. So the investor ends up getting the effectively a 50% discount. So caps are important. You can see how they work. Normally the investor gets whichever one of the discount or the cap gives them the most shares is what they get. So they don't choose between a discount or a cap. They get whichever one of those two gives them a lower share price. Any questions on caps? Just this is a big concept. I know we're going to have Q&A at the end, but just want to see before we build on this to the next section. Okay. A simple agreement for future equity is another type of security that's used very often now for raising capital. The big difference between a safe and a convertible note is there is no interest and no maturity date. So you're not negotiating either of those two clauses, which saves a lot of time and also a lot of complexity of what happens if you get to maturity on a $2 million or a $1 million convertible note, and you just don't have the $1 million to repay at maturity, which is usually the case. You've spent the capital from the convertible note to start building the business, and now you've kind of running out of capital again as you're getting ready to do your next round. And if you haven't done your next round before you hit the maturity date, you're going to hit the maturity date without the capital to repay the note. And so either you're renegotiating with the investors to an extension of the note, or there's some conversion clause that kicks in. But all of those complexities that were happening, around maturity date, you don't deal with in a safe. So it converts. So you still have the discount rate, like the 20% discount rate, and you still have the cap. On the pre-money, on the cap, sometimes you're seeing now pre-money caps and post-money caps. The pre-money cap is more favorable to the entrepreneur. The post-money cap is more favorable to the investor. So in terms of if you raise more money in the safe than you expected, or you expand the safe, if it's post-money, and we'll talk a little bit about pre-money and post-money in a few minutes, it dilutes the founders more in a post-money safe with a post-money cap. So you convert in the next financing at the discount rate of the cap. If you have a corporate transaction, you sell the company before you've raised another round, the investor can usually get a multiple back of the investment amount in the safe, or they convert at the cap and participate in the proceeds. You don't have any rights of a stockholder until conversion, and you also have priority over common and preferred shareholders. Now, sometimes with these safes and these convertible notes, you may also, another thing that sometimes shows up is you have a side letter. And in that side letter, sometimes investors sometimes ask for preemptive rights, which we'll talk about a little bit later, or information rights, or most favored nation, MFN clause. If you did another safe at a lower cap and better terms, they get to switch to that. So those are the convertible notes and the safes, which are most of the time the securities that you're using in a seed financing. Warrants sometimes show up where it's an additional incentive for an investor, maybe an investor who's moving first, acting first in investing in a side letter, or maybe it's a strategic partner tied to a strategic transaction where you issue warrants. And a warrant is a derivative that gives the holder the right, but not the obligation to buy equity, usually at a certain price before the expiration of the warrant. So an example might be a warrant holder is given the right to buy 50,000 shares at 50 cents a share. And they have 5 years to make that decision. They can wait for the value of the company to go up before they ever exercise that warrant. They can wait for it to be in the money, as they say. And it can be a cash exercise or a cashless exercise. So a warrant, again, is something that may show up as like an extra incentive tied to a financing to make the deal even more attractive, or to make a strategic transaction with a strategic partner more attractive. All right, so now we're out of securities. So the next thing we're going to talk about is negotiating. Now you're in the negotiation with the investors, so the entrepreneur, and the negotiation when you're raising financings in a price financing really breaks down into what I kind of consider to be 3 levers or 3 different areas of negotiating. The first one is the value of the company. So the first thing you're negotiating is how much of the company are you selling in the financing, and that's normally dictated by the valuation in a priced equity round. The next thing you're negotiating is investor rights and preferences. So these are preferences with respect to distributions of profit or distributions upon a liquidity event. And it also drives the investor's rights to participate in new issuances of securities and transfers of issued securities. So investors will spend a lot of time, not just, entrepreneurs focus a lot on valuation, right? It's a big focus of entrepreneurs in these negotiations, but investors and entrepreneurs, once they understand these other areas that you're negotiating, realize that it's these other clauses that are equally and sometimes in the long term even more important to understand and get right in the negotiation than the valuation, because a few percentage points difference in ownership, if you execute on your business and you have a big exit, the few extra percents that you gave up in valuation is not going to change your life. It's not going to make a big difference to you down the road. If you sold 20% versus 18% versus 24%, that difference is not going to make or break things down the road. But these investor rights and preferences and protective provisions can have a big impact on what it's like to operate the business, and some of the other things that impact the business as it's growing. And so we spoke about investor rights and preferences. The other area that's really important is investor protections, is the other area of negotiating. And this drives the level of control an investor, who usually holds a minority ownership interest in the company, exerts on major actions of the company as a shareholder or through board seats. So that's the other big area you're negotiating. So,
hey, Anthony, before we continue, we have quite a few questions in the chat.
Sure.
If we want to go over some of those really quick.
That would be great.
So the first question is from Peter, and he has said, are there more common terms to be negotiated that investors are willing to bend on? What are typical non-negotiables, timeline, cap, discount, etc.?
Yeah, so we'll start to get into some of the terms in the rights and preferences and protective provisions. And is there someone not on mute? All right. So there's definitely areas of negotiating. So in the things that you just spoke about, I mean, normally there's going to be a discount rate, and what you're going to negotiate with the investor on is the amount of the discount rate. So while often it's 20%, for a discount rate, sometimes it shows up a little higher or lower. The cap is very much a negotiation with investors as to what the cap amount is going to be. And those are the only two things you're really negotiating in a safe. And again, most of the time you're not negotiating the discount rate, which is often 20%, you're just negotiating the cap. In the convertible note, the other areas of things that you're going to negotiate more is what happens at maturity, and with respect to conversion is going to be kind of a term that maybe is a little bit more negotiated. In terms of some of the other rights and preferences, as we go through them now, in the next segment, I will talk about some of the types of things that could be negotiated in a priced round with investors.
Okay, great. Thanks. The next question is from Don, and he says, I've had some attorneys recommend to companies that convertible notes only have a discount with no cap. I've also had several investors tell me that they don't want to do a deal without a cap. What are you seeing out in the marketplace?
You know, we're seeing more deals with caps than without caps. It comes down to leverage in the deal. Any negotiation in any deal is going to be tied to, are there more investors that are interested in coming into the deal than there's space in the deal? Is this a very competitive deal from the investor side? Or is this a deal that's a little bit harder to fund? And so you don't have as much negotiating leverage, right? So we saw from a cap perspective, from a discount perspective, we're not seeing a lot of changes in variance in where the discounts come out. On the cap, from an investor's perspective, again, if they feel like they're taking a lot of risk, unless it's a deal that's really very competitive, and you're able to either have a very high cap or negotiate for no cap, you're usually seeing some sort of cap. And if it's a high enough cap, it also starts to set a baseline value. It's not a today value, but it does start to set a baseline value for your priced round. So even if you do have a cap, if it's high enough, there are some benefits in starting to put some soft value out there for the business.
Okay, awesome. Thanks. The next question is from Michael, and he says, is cap often thought of as valuation?
So, you know, a cap is a value, right? It's the value that the investors are going to convert at when you do a priced round. So it is a valuation, but it's not the valuation of the business today, meaning if it's not priced as the share price today, it's more saying to the investor, when we do a raise in the future, you're going to have two ways to benefit. Two ways to choose from that benefit you. One is you're going to get a discount to the next round, which gives you some protection and advantage. And the second is you're going to have this maximum valuation that you invest at. So usually you'll see a cap will be higher. You'll be able to get a higher cap than you would a priced round valuation between the two. So it is a valuation term, right? It's a cap. It's the valuation cap, and it's usually a little higher, or sometimes more than a little higher than what you would see pricing that round today.
Okay, awesome. We'll ask 3 more questions and then we'll move on, and we'll have more questions at the end. The next one is, Mark is wondering, ever have different caps for different investors, or is this just asking for trouble?
You know, when you go out to investors and you're doing a round, typically you have the same cap for that series. So you may have a series 1 safe, and let's just say you're going to do a $5 million cap. Or a convertible notes, and you do a $5 million cap on that series. You go out, everyone who comes into that series will usually come in at the same cap. Let's just say before you raise the full amount, you get a major customer contract, millions of dollars of revenue, and you decide that the value, you don't want to keep raising money at this, even though you have room left in the round, you don't want to keep raising money at the same cap. You can stop that note or that safe and issue another safe, a series 2 safe, where everything is the same except it's a higher cap. It's now $10 million cap instead of a $5 million cap. So typically you don't, in the same series, have different caps for different investors coming in at the same time. You raise under a cap, and if the business changes, you then issue your next safe or your next convertible note at a much higher cap.
Great. Okay, next question is from Don, and he says, which of the 2 safes is more common today, pre or post money?
You're still seeing more pre-money safes, I believe, than post-money safes. The pre-money safe, again, is more favorable to the entrepreneur than the post-money safe is more favorable to the investor. So I think it's a little bit reflective of where, you know, which side, the entrepreneur, the investor, has a little more leverage at the moment. But I do, in terms of what we're seeing, it's more pre-money than post-money. And also, Carta is now putting out benchmarks. They have about 20,000 companies on Carta, and they're starting to put out benchmarks on what they're seeing happen in these, with these types of transactions. And I think that's trending the same way there as well.
Okay. Last question is from Thomas, and he said, do you see a difference in East Coast, West Coast terms in preference to converts or safes? Which coast prefers what, or is this not a difference you're seeing?
You know, East Coast to West Coast, the big difference is your valuations tend to be higher if you're dealing with West Coast than East Coast. You're seeing higher valuations in terms of that. That's definitely, you know, something that we're seeing. In terms of usage of safes are almost like ubiquitously used on the West Coast, but we're starting to see more of them on the East Coast. Like, we're doing many more safes now than we were before in East Coast deals. But, you know, it started on the West Coast and it took time to kind of be more frequently used on the East Coast, but we're still doing a lot of safes on the East Coast.
Okay, awesome. We can move forward with the presentation now, and if you have more questions, please ask them in the chat, and we'll go over more questions at the end of the presentation.
Great. All right, so we were talking about pre-money and post-money, and fully diluted basis are 2 concepts that are important to know with respect to valuation. Pre-money valuation is the valuation of the company, not including the new cash that's being raised. post-money valuation is the valuation of the company that includes the new money that's raised. So why is this important? I'll have an entrepreneur come to me and say, I just got a term sheet. I agreed with the investor. We're going to be raising at a $2 million valuation. I'm raising $500,000. And the investor will say, the entrepreneur, when I asked him, is it pre-money or post-money, sometimes say, I don't know which one it was. But it makes a real difference if it's pre-money or post-money. If it's pre-money and you're raising $500,000 on a $2 million valuation, the value of the business after the $500,000 hits your bank account is now worth $2.5 million. So the investor will receive 20% of the company in that type of investment, right? $500,000 divided by the 2.5 million post-money valuation, 20% of the business. But if the business had a 20% was post-money 2 million valuation, then the business, when the money hits your bank account, is worth 2, not 2.5, which means it was really worth 1.5 before. And so the investor receives 25%. So in both instances, it was a $2 million valuation. Both instances, $500,000 was invested. But if it's pre-money, the investor walks away with 20% of the company. And if it's post-money, the investor gets 25% of the company. Really important concept to know which one you're negotiating. The next important concept that shows up in term sheets that you're going to see is something that says fully diluted basis. So, a valuation on a fully diluted basis. And what that means is, if you remember earlier, to get a share price that you're investing at, you take the valuation and you divide it by the number of shares outstanding. That gives you the share price to figure out how many shares somebody is receiving for their investment. The question is, what goes into that denominator? Is it only the shares that are issued and outstanding at that moment in time? Or if you've set aside a 15% or 12% or a 10% equity incentive plan, and you've never issued actual stock options before, does it include those in the denominator? And does it include warrants that have been issued but not yet exercised? Well, if it's on a fully diluted basis, it includes all of those. And almost every time you deal with an investor, they don't want to be diluted by the option plan or the warrants. So almost always they're going to do it on a fully diluted basis. And so you need to make sure when you look at your share price and your valuation that it's going to be calculated that way. So here's an example: 2 million shares issued and outstanding, 500,000 shares in an option plan, 500,000 being invested at a 2 million valuation, $2 million divided by the shares outstanding. If it's not a fully diluted basis, it's just on what's outstanding. It's 2 million divided by 2 million, or $1 a share. 500,000 shares, you selling at $1 a share, $500,000 at $1 a share, people get 500,000 shares. On a fully diluted basis, you're going to include that 500,000 options. So it's 80 cents a share, and the investor, same valuation, same amount invested, but here the investor walks away with 625,000 shares versus 500,000 shares. Again, when you're negotiating valuation, just like pre-money and post-money, understand what your cap table looks like on a fully diluted basis before you agree to a valuation with investors. Particularly if you have a big option pool or warrants or a lot of shares that are outstanding. Okay, the rights and preferences, some of the rights and preferences that you're going to see in a term sheet are liquidation preferences, which could be participating or non-participating, preemptive rights, information rights, drag-along rights, anti-dilution rights. We'll talk about all of those today, but then there are others like dividends, rights of first refusal, redemption, registration, and board seats that we won't touch on, but you can see how many rights and preferences are being negotiated in a deal. So the liquidation preference is a mechanism that the investor uses to get back their original investment or a multiple of that investment before any distributions to the common stockholders. And usually it occurs upon a liquidity event like the sale of a company or a merger or liquidation. So if somebody has a one-time liquidation preference in their term sheet and they invest $1 million, they get the first $1 million before the first dollar goes to the common stockholders. If it's a 2x liquidation preference, they get the first $2 million before it goes to the common stockholders. So keep an eye out for liquidation preference. The next important thing is it participating or non-participating? Very important one to get right as an entrepreneur at the beginning. Non-participating preferred means there are two doors. In one door, the investor walks into that door and they get their money back, their one-time liquidation preference. In the second door, they convert to stock, common stock, and they get their percentage of the company. So if they own 20% of the company and it's a $10 million sale, they can get their $2 million, their 20% of that $10 million of the proceeds. But the big thing in non-participating preferred is the investor they get whichever door gives them more money is the door they have to go through. In participating preferred, which as an entrepreneur you really want to avoid agreeing to early on or ever, the investor gets both doors. First, they walk into door number one and they get their one-time liquidation preference back. Then they walk into door number two and they get their percentage ownership. This may not seem like a big deal when you have participating preferred and you've just raised $1 million, but when you raise $10 million in your next round and people see you gave participating preferred in this round, they're going to want the same thing. Now you've got $11 million. Then you do $20 million in your next round. Now you've got $31 million that go out before you even go, everybody goes together into door number two. So really important one. Preemptive rights protects investors against dilution from future financings. If the investor owns 20% of the company now and they have a preemptive right, it gives them the right to take 20% of the next round and keep themselves whole. Often it's a good thing for your old investors to participate in your next rounds. It's a good signal. Sometimes you'll reserve it, though, for major investors. So like just say somebody who invested at least $250,000 or $500,000 in your round to give them preemptive rights, because sometimes with the future rounds, the lead investor wants 90% of the round. And if you've got 40% of your company with preemptive rights that 40% of that round is allocated already, you have to renegotiate with your existing investors to kind of have them waive all or a portion of their preemptive rights. Information rights are rights to information like income statements and balance sheets and cash flow statements. These could be unaudited early on and then become audited later on, and they could be on an annual, quarterly, or monthly basis. It may include other information like budgets and key metrics. And what you weigh, it's always good to and fair to give investors information rights. And the truth is, as an entrepreneur, the more up-to-date and informed your investors are about the financial status of the business, the better it is for the investor, but also the better it is for the entrepreneur, because you're going to have hiccups and you're going to have times when things don't go as well. And you don't want to be surprising investors with, wow, I'm almost out of money, a month before you're almost out of money. They should be there with you, seeing all the good things and the things that are challenging. And so it is good. What you're just weighing is the frequency. So should it be on a quarterly basis, a monthly basis, an annual basis? That's more what you're negotiating with. And if it's very frequent, sometimes you're limiting the frequent information rights to major investors, similar to what you did with the preemptive rights. Drag-along rights is important. That's the right if the board of directors and a certain percentage or class of shareholders say we're going to sell the company, everybody has to sell. No one can hold up the sale by owning a small number of shares and refusing to sell. And so the drag along right protects the investor, but it also protects the entrepreneur who wants everyone who comes in as a stockholder, preferred or common, to be subject to the drag along rights. Anti-dilution protection: if you raise money at $5 now, and in your next round you raise money at $3, this is where this clause kicks in. A full ratchet means even if you sold a small number of shares at $3, the investors who came in at $5 have all their shares repriced to $5 on conversion. And then you have a narrow and a broad weighted average, which is the most favorable to entrepreneurs, and the one that we see most often is a broad-based weighted average anti-dilution clause, which takes into account not only the fact that you raised money at $3 in this round where it was $5 in the last round, but it also looks at how many shares you sold at $3 and how many shares that represents over the fully diluted full cap table. So it ends up being more favorable to, so maybe instead of dropping down to $3, it drops down to $4.70 if you didn't raise a lot of shares, issue a lot of shares at that lower price. The next thing, which also in the long run is often more important than valuation, is the protective provisions. These provide investors who control less than 50% of the shares or less than 50% of the board seats with certain power over veto rights over certain designated actions that require either a supermajority of that preferred Series A investors for those approvals, or the majority of their directors have to approve it as well. So you could say, well, I control the board, but if the investor has one Series A director on a 5-person board and they have protective provisions, you need not only the majority of the board, but you need that Series A board member to approve it as well. And you may say the investor only owns 15% of the company, I own 85%. With the other founders, but you need that 15% to approve an action. That's where this kicks in. So some of the things that show up are like amending the certificate of incorporation, redeeming equity, changing the nature of the company's business, changing the size of the board, issuing new shares of stock. And there maybe you can negotiate with investors where only if you issue shares that are superior to their shares, or pari passu and superior to their shares, does it, do you have to get approval? Hiring or firing key employees, or changing compensation of founders, bringing on debt above a certain amount, or selling the company. And there again, maybe if you give the investors at least a 3x return, you don't need their approval for the sale, or some X return, you don't need their approval. But these are the kind of provisions that affect running the company going forward and growing the company. So understanding these clauses and what provisions you've negotiated for is important. After you've done with that, you hit due diligence. There's business due diligence, financial due diligence, and legal due diligence. In legal due diligence, investors are going to be looking at all of your formation documents and the founders' documents and all of the whether everything was issued properly. They're going to be looking at the cap table, making sure everything is captured in the cap table and all of the financings that showed up were done correctly. They're going to look at all of the management team documents, the founders' agreements, the consulting agreements, the employment agreements, the any material agreements with customers, intellectual property like patents and trademarks. They're going to also look at proprietary information and invention assignment agreements, making sure everyone who is on the team assigned intellectual property that they worked on to the company, and then if there's any regulatory or litigation risk. And so it's coming. In every financing, you're going to have due diligence. The more prepared you are and organized, and if you early on you didn't have a lot of money and some things weren't done the way you should have done it, you want to know that ahead of time, step in, get it corrected before you go into due diligence. It's not too late to go in and correct things with your attorneys. You don't want the investors to be the ones who find it. And you don't want to not be organized so that when investors ask to start due diligence, you disappear for 3 weeks getting ready for it. In terms of documents, in a Series seed financing, you have a stock purchase agreement, an amended and restated stockholder agreement, and an amended and restated certificate. In a Series A preferred stock, you have the stock purchase, and the stockholder agreement is usually broken out into an investor rights agreement, a right of first refusal, a voting agreement, make up the stockholder agreement. And you also then have the amended and restated certificate, and then there's some other agreements that go along with that. In a convertible note, you have a note purchase agreement and a convertible promissory note. Sometimes it's one, but usually it's two. And then the SAFE is just the simple agreement for future equity. And then the last thing is just every time you raise money, there is security compliance issues. The ability to raise money from investors is regulated by the Securities Act of 1933 and state security laws. Under Section 5, all issuers, which are you, the founders and entrepreneurs selling any sort of security in your company, have to register that with the SEC unless it's exempt. And then you have to look for exemptions. So 4A2 says that Section 5 doesn't apply if transactions by an issuer do not involve a public offering. And then there are two safe harbors, which is where most private capital raising happens through these safe harbors, called Reg D. Some people may have heard of people saying, have you done a Reg D filing? 506B is you cannot broadly solicit or generally advertise. And that's where most of the exemptions happen there. And then 506C, you can broadly solicit and generally advertise. That's where the crowdfunding, where people are starting to broadly solicit and generally advertise. But you need to have third-party accredited investor verification. So you have to have accredited investors who are verified. You file the Form D with the SEC, and then you also have to look for every investor where they're located, what state they're in, to see if you have any state filing requirements. Every time you raise money, you have to look at this. Very important. That was a lot, I know, but as Tien said, we'll share the presentation. I think, Tien, this will be available to people on recording as well. And I'm happy, to answer some questions now. And I'm also on the Slack channel that was set up for this masterclass. And if people just have some questions they didn't get to ask today or that they thought about after today, you can reach me on the Slack channel, as well as my email address, amillin@schulmanrogers.com. And remember to take a look at next.law at www.next.law, and you'll get a real sense of kind of what we're doing for startup and emerging growth companies.
Awesome. Thanks so much, Anthony. We do have some more questions. So we'll go over some of those. Peter asked, do you have an Excel model that we can use when calculating investments and dilution over time? I built my own and found a few online, but would love to see what you use. I like to learn from the best.
We have built out models that we use to model financings. It's one of the first things we do when we're working with clients is build out a cap table and be able to run kind of pro forma modeling of what happens under different scenarios. So, people can reach out to me and we can kind of talk about the best way to model that.
Okay, awesome. Next question is from Don. He says, I've heard from a major angel group, over 30 million invested by their members each year, that the standard is participating preferred for their investors. If this is true, there are several companies accepting participating preferred terms. While companies may not want to grant participating preferred terms, many appear to be accepting this deal term. Can you comment on how common it is to grant participating preferred terms?
Yeah, we usually fight very, very hard for the reasons that I spoke about to not do participating preferred early on. Maybe when you get into later rounds on a very big investor, it's something you might look at. But generally, I will do whatever I can to not do participating preferred early on. But look, sometimes you need capital, right? And you're choosing between participating preferred and not in business, or participating preferred and you're not going to get capital. And so sometimes you do, as an entrepreneur, take on terms that wouldn't be your first choice, and you figure you'll deal with it a little bit later. So you also have to be realistic and understand how much leverage you have in these negotiations, because we've done participating preferred with clients before, but in those deals, those clients kind of went in eyes wide open. They knew what they were getting into. They knew that it wasn't as preferable, and but felt like it was what they had to do to get funded. And at that point, we said, you know what, this is what you need to do to get funded. But if you can find groups who would give you non-participating preferred, it's better to not set that precedent.
Okay, thanks. Next question is from Michael. He said, I just did the Form D online and the filings with the state. Can you tell more of us about this?
Yeah, so the filings with the state are a little bit more complex. Every state is different and they have very different rules. It's based on number of investors and amount that's raised. And you have to look, there you may want to just speak to an attorney to just make sure you're getting the blue sky. Some states have self-executing exemptions, meaning if you fit within certain criteria, you don't have to file. It's self-executing. Others, you don't have to file, but you do have to register and pay a fee. So, we have somebody who specializes in that, and so do most law firms that deal with securities law. So that's one that you really have to look at each state. There's not like one. It's not like the Reg D filing, which is like one filing with its own set of rules.
Okay. Next is, how often do you see companies raising both equity and debt at the same time, basically two different securities? What are the legal issues they need to be aware of if they do this?
Yeah, so, when we said before, like if you're raising a convertible note or a SAFE, or you're doing a price round, usually you're not doing multiple raises of different securities at the same time, because it's a little bit hard for the investors to, you don't want to give investors different types of terms or different types of options. In terms of debt and equity, sometimes you'll see that happening at the same time. Like we've seen, where somebody comes into a debt, raising some debt, and the equity, they want to see an equity raise along with the debt raise. And so it also depends on the different uses of the capital. So sometimes you have capital that is really much easier to raise through equity, like you're using it for building your business, not for purchasing inventory in a business that's up and running. So there's more risk to that capital. So while you wouldn't do multiple safes or often a convertible notes and a safe at the same time, I have seen debt and equity.
Okay. Next question. What are your thoughts on crowdfunding in general, as well as anything specifically that issues should know about? What platforms are most credible? When do you see this being a real thing for companies raising more than $3 million?
Yeah, it's interesting that some of the biggest, there's been new regulations that were just approved and have come into play in the crowdfunding space. And if you go to our website, you'll see we're actually putting on a seminar on these new rules, a crowdfunding seminar coming up very soon on that. With the new rules, I believe you can now raise up to 5 million. Some of the big negatives were, number one, you were limited in the number of the size that you could raise. And also, investors, when they came into the cap table, didn't come in through like a special purpose vehicle. So if you did 1,000 or 1,200 or 3,000 investors putting in $500 or $50 or whatever it is, that's a lot of people in your cap table. That's very scary for the institutional investors who are coming in later. So sometimes that aspect of crowdfunding plus the cost of it versus all you could raise originally was a little over $1 million. The cost to do it plus having all these investors in your cap table were a challenge. Now you can bring people in, believe you can now bring people in through a vehicle so that only the vehicle shows up in your cap table, not all the individual investors behind the vehicle. And number two, the amount you can raise is higher, much higher, so that the two big challenges in doing crowdfunding, I think they've dealt with very well. And so we're seeing, I think we're going to see a lot more crowdfunding because of those two changes. There are a lot of different platforms out there. They all have different focuses or specialties or the way they work. And but I do think with these new rule changes, it's a much more attractive option.
Okay, great. Thanks so much. I think that is all of our questions. If anyone else has another question, feel free to speak up real quick. But I think that's it. Thanks so much, Anthony. That was great.
And again, like I said before, I'm reachable by email. If you just didn't have a question you had time to ask today or just thought of something in a few days that you wanted to ask, I'm reachable through the Slack channel that Connectpreneur set up for today's seminar. And I really appreciate everybody taking the time to join us today. And thank you again to Skylar and TN and Connectpreneur.
Thanks again, Anthony, and thanks everybody for joining us today. This concludes the formal part of our meeting, and Anthony, I think, agreed to stay on for a few extra minutes if any of you have any pressing issues or questions since you're already on. So I'm going to pause the recording. Please indicate if you're interested in getting a copy of the deck. Skylar will take care of that. And as well, if you came late, we can send you the recording too. So thanks for joining us. And we'll keep the line open for a few more minutes if anyone has any questions.